you're done with learning skills?
Yep.
Yes. I did not realize last week, until after the last time we met on Wednesday, that that was the real explanation for the odd behavior I saw from you guys last week, where basically your minds and attention were elsewhere. If I had sort of put two and two together, I would have realized that, because it's an annual ritual where we who teach your doctrinal classes lose you completely. And this will recur in the spring when you're working on your briefs. We lose you yet again. So now I understand what was going on last week. And I guess I can. So I am anticipating, although this may be a futile hope, who knows, that more of you will be back engaged now that you've handed in your memos, and at least most of you, and that by Wednesday you will have gotten over that hump now. Okay? Anything on your minds?
Is it possible, or has it ever happened, that this is a common law question, all right, but that two constitutionally protected rights conflict with each other, and like,
Sure.
how would that be resolved? Like, does
The universe explodes. It's like matter and antimatter coming together. If it happens, basically we are all sent back into the dust from which we know. For example, the right to a free fair trial. That is a criminal defendant's right, so I turn it back to criminal law at least a little bit. And also the right to free press. Free press wants the press wants to cover a trial. Maybe they do so in a sensationalistic way. This is the defendant's right to a fair trial, right? So can you limit coverage of a trial by the press in order to safeguard a defendant's rights so the jury doesn't have its views tainted, etc. Another example is the right to equal protection of the law. Does that conflict with somebody's right to free speech when what they want to speak is a hate crime? What they want to speak is in support of hate that may deny somebody else's equal treatment under the law, right? So there's various ways in which those can come into conflict. And the answer is that no constitutional right is absolute. Every constitutional right, this will lead to you being incredibly frustrated with common law when you take it, and you will wonder, at least some of you, why did you ever come to law school while you're taking common law? Because it's all gray areas. It's all balancing tests. We balance the governmental interest against the asserted right. In the case of conflicting constitutional rights, that balancing gets all the more complex. But it's still the same basic task. How do we balance those rights so that we preserve as much of each of them as we can? And there's no one answer. There is balancing. In the case, for example, of the fair trial, the court has said that there is a very strong presumption, again, even in service of the right to a fair trial, against prior restraints on speech, stopping the press from covering trials, publicizing information. And because there are other means that trial judges can use to alleviate any effects from publicity on the right to a fair trial, you should almost never resort to limiting the press. You can have delay the trial until the publicity dies down. You can have change of venue. You can have careful questioning of prospective jurors, right? For the other means available, and as long as there are alternatives, you shouldn't compromise the right to free press. So that's the way the court tries to do it. It tries to look at, when it balances, how can we best balance that we preserve as much of both conflicting rights as possible. It's warming me up for Thursday when I teach common law. Appreciate it. Anything else? Okay. We get to resume with Wilson against People. If you recall, we had to sort of build up to this weird dynamic between Wilson and Pierce. Wilson ultimately being really unhappy with Pierce as they got drunker and drunker, accusing Pierce of stealing his wallet. And eventually they get to this building where they are going to try to steal from this drugstore. And if you recall, Wilson actually boosts Pierce up. They tried several doors, they were all locked, and they get to this transom, and Wilson boosts Pierce up, and he breaks the glass, enters the store, and is going through the cash register. What was Wilson doing while Pierce was going through the cash register?
Calling the police.
I beg your pardon?
Calling the police.
He was calling the police to come to Hecker Brothers Drugstore. So on the one hand, you've got Wilson helping Pierce, and on the other hand, you've got Wilson stabbing him in the back by calling the police. So what happened when the police got there, Ms. Ramaswamy?
Once they got there, they detained / arrested Pierce, but then they also...
Well, did they, at the drugstore, detain Pierce? That what happened?
No, Pierce escaped out the back door.
Pierce escaped out the back. Wilson told them Pierce is inside, and he told them he had boosted Pierce into the drugstore, but Pierce escapes. But Wilson isn't done helping the police. What does he do next, Mr. Razor?
He sends them back to the hotel they had previously visited, and they arrest Wilson there.
And why does he say he had helped both arrange the burglary and to allow Pierce to do it?
He wanted to catch Pierce in the act, kind of as revenge for stealing the
As revenge for taking his watch. And he said, well, this is the only way I think I might get it back. Right? The only way I think I might get it back. So he said he wanted to apprehend Pierce and turn him over to the authorities. He wanted to catch him in the act. Right? So what did the trial judge tell the about the defense's theory? The defense's theory here is, first of all, what is the defense theory?
That he was merely a spy, kind of like an undercover cop.
That he was not an accomplice to Pierce, but in fact an undercover assistant, I guess, because he wasn't really a police officer, to the police. Okay. So what does the trial judge tell the jury about this theory? What instructions is the jury given?
It says that one who attempts to detect the commission of a crime and others must themselves stop short of lending assistance or participation in the commission of a crime.
And so what would that lead the jury to do with that defense in this case? If that's the law, if you have to stop short of actually rendering assistance and participating in the commission of the crime, how would that lead, what outcome would that lead to in this case?
It means it's not applicable in this case because he did lend assistance to...
Right, and the judge says one may not participate in the commission of a felony and then obtain immunity from the prosecution on the ground that he was a mere detective or spy. You can do this, you can try to maybe lead the person in, you can try to find out what the person's doing, be an undercover person, but you better not actually lend assistance. That crosses a line, and if you cross that line, you will have ended it. So what becomes the key in terms of our categories of elements? What element, according to the trial judge's instruction, is the key to culpability here?
The act.
The act, right? It's the act. And essentially, as far as the trial judge is concerned and its instructions to the jury, it doesn't matter what you tell, what your motive may be, right? It's just that you committed this act, even if your underlying real motive was to help the police. The act makes that irrelevant. The act makes that irrelevant. Okay? And does that end up being? What does the appellate court say about that, Mr. Razor?
They reverse.
Why?
Because they say that the intent is more important, and that it was the jury job to decide the intent of Wilson, and that jury instruction was made that way.
Trial judge, if you commit the act of assistance of some kind, like boosting him through the transom, you cannot gain immunity from prosecution because even if you show you didn't intend to aid. Appellate court, intent matters. To put it in just one pithy little phrase, intent matters. And what intent must be shown by the prosecution? Lineweaver?
The same as the principal?
Ladder?
The same intent as the principal?
You must share the intent of the principal. Right? You must share the intent of the principal. Okay? What should be the outcome of this case under that rule? If that's the rule, you have to share the intent of the principal. We know we have to at least remand, because the jury wasn't instructed to make a finding that it has to that Wilson shared Pierce's intent, right? Should there be a remand for a new trial? Is that what the Court of Appeals does, Ms. Lineweaver? And so, what should happen? What should be the outcome?
Well, Wilson would say that he didn't share the same intent, so he should be,
I beg your pardon?
because Wilson would claim that he didn't share the same intent. And I think that's hard.
Make that argument for me. You're arguing to the jury on behalf of the defense. You don't sound very convinced of your client's case.
I think the fact that he assisted them.
But that's what the trial judge said originally, merely the fact that he assisted him. What's your argument? He hired you, he's expecting the best. What?
I don't really believe he should get off, so.
And there will be times when you don't believe your client's arguments, Ms. Lineweaver, and you're going to have to suck it up and pretend you do. So be that actor. Give us an Academy Award caliber performance.
Do you believe that he's going to watch?
Do we care about that?
Well, it shows that he had criminal intent. The other peers.
Do we care about Pierce's criminal intent? What did the court say is your line of defense?
I don't think he doesn't have the same intent as Pierce.
So you want to create a narrative, a story, for the jury to say, well, what was his intent?
To act Pierce.
Good. And ladies and gentlemen of the jury, the judge has just instructed you, right? The judge has just instructed you that you must find that my client shared the criminal intention to commit burglary of Mr. Pierce. You should reject the prosecution's contention that he shared that intent. Tell me what facts from the evidence would lead you to be able to argue the jury that he didn't share that intent.
That he wasn't trying to steal from the store.
How do we know that? What actions, what facts? Good. There you go, right? Ladies and gentlemen, anyone who intended to make this burglary successful would certainly not have had as his first act, once Pierce was in the store, of calling the police. What else did he do that would indicate he didn't want this burglary to be successful? At the hotel, right? He did all sorts of things that would indicate he very much did not share Pierce's intent. And ladies and gentlemen, jury, for those, look at the facts. No, there's no way you should be able to come to the conclusion that he shared Pierce's intent. Fair? Did you convince yourself?
Yeah.
Excellent. Excellent. Right? Now, who's going to be our prosecutor? That's the most hesitant prosecution I've ever seen in my life. What's the, how are you going to argue to the jury?
Wilson did share intent. He shared the intent with Pierce because both of them wanted Pierce to steal from the drugstore.
Okay, and how do you answer these facts? Because you go last. The party with the burden of proof always gets to go last in doing a closing. So you're going to hear this from Ms. Lineweaver, ace defense attorney. How are you going to respond to how she characterizes the facts as showing a lack of intent to further the burglary, a lack of shared intent with Pierce?
Well, that assisting him through the transom, getting into the drugstore, that crossed the line and maybe into the traffic. But so he does have intent for Pierce to steal something, and he's assisting.
What differs between them? If it's not a differing intent, as the defense says, what does differ between them when it comes to their purposes, or as opposed, because they both participated in terms of the act in getting Pierce into the drugstore. How will you try to argue that Wilson is different?
Well, he may not want to steal something from the drugstore, but he's assisting someone else.
That's still focusing on the act.
What did you think was going to happen when he lifted him into the drugstore? I feel like that's pretty clear his intent.
They shared the intent, the prosecution says, to get Pierce into that drugstore. What differed, if anything, was the reason Wilson had that intent. He still had the intent to allow Pierce to do the burglary. He may have just had a different motive, and motive is different from intent. We use those terms interchangeably. But if you're the prosecution, you say, yeah, he had a different motivation. He wanted to trap Pierce, maybe. Let's assume we believe that. But he still intended to trap him in what? Committing a burglary. So his intent was, for reasons that are nefarious from Pierce's point of view, for motives that were not the same as Pierce's. Pierce wanted money from the drugstore. Wilson wanted to catch Pierce, but they both shared the intent of having Pierce commit a burglary. That's how the prosecution would argue, right? Share the intent. All right, show of hands. How many of you as jurors vote to acquit? Higher, higher, higher. How many of you vote to convict? Wow. I would have been on the acquit side. And the law is on the acquit side. The law would say he did not share the intent. Right? He did not share the intent. And it would reject this idea that the motive is distinguished from intent. But there's a good argument on both sides. And a reasonable jury could come out either way. So this is a case the prosecution might be able to win. Okay? The other argument is, I think, to sort of flag for your attention is, do we really accomplish anything in the criminal justice system if we treat Wilson as having shared an intent, as having been an accomplice of Pierce? Right? When they really do have such differing mental states about why they're doing what they're doing, when in fact Wilson is plotting adversely to Pierce, do we want to treat them as accomplices? Do we want to treat them as accomplices? He is certainly taking a huge chance that events will unfold in the way they did, and that he'll be able to prove that his intent was to facilitate it. Remember, facilitation is acting with knowledge. Whereas intent equals complicity. And so if we really want to prosecute Wilson, I would suggest to you one way to do it, at least an option in the prosecution's toolkit, is this crime. Because he did have knowledge of Pierce's criminal purpose, but it's hard to say, not impossible for the reasons we talked about, but hard to say he shared the intent.
So as far as why would we want to punish Wilson, I kind of see him as this entitled guy who, thinks his watch was stolen by Pierce, whether or not that was true, who wanted to take the law into his own hands. We don't encourage vigilante justice.
Yes.
And he, by any means necessary, he was gonna get his revenge, which included, you know, damage to the store. So, you know, if, that's why I would wanna punish him, because he just wanted to do whatever he wanted to do in order to accomplish his own purposes.
That's a great argument. I wouldn't say it's not unreasonable at all. I don't know if I share it, but that's not in any way important. The question I would then ask is, even if there's a reason you'd want to punish this guy, and those are good reasons you might, is it reasonable to punish him as an accomplice to somebody who he, as I said, was so adverse to? And maybe the way to do it is to do this instead of this.
So does the fact that Pierce like admitted to robbing stores before like add any sort of like factor and having weight when?
How would you try to argue it had any weight?
Just saying like you could say Wilson was, although like kind of entrapping the Pierce, like was in a way almost like committing a public service by getting this guy like off the street from
Entrapment as a public service. That's my next law review article. By the way, it would be extraordinarily difficult to argue this had anything to do with entrapment. A, entrapment has to be by a government official, and that Wilson was not. And B, the substantive rule for entrapment, which we don't have time to get into in detail, is that if the person already has a predisposition to commit the crime, then when the government creates the opportunity for him or her to act on that predisposition, it is not entrapment. If, on the other hand, there is no demonstrated predisposition, then it can be entrapment. For one of the reasons you argued, Pierce's history, and in fact this particular drugstore, if I recall correctly, you would easily be able to show predisposition, even if Wilson had been a governmental agent. Okay? Call.
What if it was the same situation, but the crime was more serious? Like, he told him that he had murdered people, and he set him up to, like, here's a gun, go kill Bob, and then he calls the police while he's on his way.
Right.
I feel like that's what
And
he
Bob
does.
dies.
Well, Bob doesn't die, but he's like...
Let's make Bob die. Why not?
Bob dies.
Bob had it coming.
So, I feel like there's definitely some criminal culpability there.
And what's wrong with facilitation?
I think that they should be held to the same liability because they both have this same, like he sent him to go kill Bob.
I certainly think that's a viable theory. It is certainly not the way most courts approach it. But you guys are the next generation. Change the way the law looks at this. That would be an interesting approach. And maybe you do reserve it for more serious crimes, right?
It says that Wilson was the son of a deputy district attorney and was
Right.
employed by him. So does that not make him a government agent?
If I'm, I don't know, let's see. If I'm on the road and get really annoyed with the person who's driving 50 in the left lane on the Watterson, okay, and I decide I've had enough with these pokey drivers and decide to ram this person until I ram them off the road off the Watterson into their fiery deaths. Am I acting in my capacity as a government employee? Was Wilson acting in his capacity as an employee?
It was motivated for personal reasons.
I'm sorry?
It was motivated.
He was totally acting in his personal capacity. Okay? But that is going to be how my life ends when I go to jail because I killed somebody driving ahead of me 50 miles an hour in the left lane. Just so you know. Yeah.
So then we've already, I know we've already kind of discussed this and made sure I got it. So we've pretty much overruled this kind of idea that motive is not really in like the legal sense like important or relevant?
Well, I think if I was the prosecutor, and this is the case I had, and I had decided, maybe for reasons that Ms. Mwanga has suggested to us, that I think this is somebody who should be prosecuted, and not just for facilitation, because that's always another option, you know, I might try it, and try to convince the trial judge that, let's say you're in a jurisdiction that follows the same rule that the court applies here in Wilson, that you have to share the intent. I'm going to try to argue that intent, all that's necessary